Good morning. Please be seated. This is the time set for oral argument in Auto Safety et al. V. Goodyear, 1CA-CV18-0244. Out of respect for counsel in the court, please turn off your cell phones or at least put them on vibrate. Each side will have 20 minutes for argument. Appellant, you may reserve a portion of that time for rebuttal if you wish, but you will need to keep track of the time yourself. We have read your briefs, conferenced this case this morning. We are familiar with the facts and arguments, and we encourage you to keep that in mind as you present your case. These proceedings are being recorded and will be posted to YouTube, so before you begin your argument, please state your name and the party you represent. With that, counsel for appellant, you may proceed.
May it please the court, Susan Freeman on behalf of the Goodyear Tire and Rubber Company. If this court upholds the decision below, it will be the first appellate court to hold that trade secrets can be released to the public because they relate to a potential risk to public safety, and so the public can judge whether an arguable misuse of a protective order enabled some misconduct.
What is our standard of review for what the trial court did?
Your standard of review is abuse of discretion, but when you have a violation of the standard for that discretion, then it is an abuse of discretion as a matter of law. And that did happen here.
Which is why abuse of discretion can mean anything we want it to mean, right?
Well, no.
I'm being serious. When the trial court misapplies the law in reaching a discretionary decision, we review that de novo and call it abuse of discretion. Is that not the way it works?
Reviewing it de novo is the important part here. Let me turn first to the sealing point, because the trial court said in conclusion of law 25 that it was balancing this potential risk and the public need as part of its determination whether documents should be unsealed. And if the court looks to Rule of Civil Procedure 5.4, there is no factor there for a potential risk. There is no factor whatsoever for evaluating whether the plaintiff needs that.
Did you just cite Rule 5.4?
Yes, I did.
Okay, because that did not figure into the analysis of either brief or the trial court's work. I mean, these cases are litigated like scorched earth, and yet the governing rule never made it into the analysis. The
briefing was done in 2017, and the rule took effect January of 2018, and the court made its ruling in 2018, and that, I suspect, is why
right, but
the
appellate briefing, the court made its ruling after the governing rule took effect, and the appellate briefing did not address the rule, which leaves us wondering whether anybody has applied the correct standard here and whether this case might need another trip to the Superior Court.
The rule, Your Honor, follows the case law that we cited, which is Nixon, Kamakana, DRK, which say that a trade secret is a compelling reason for keeping documents sealed.
Well,
and
we did our best when we drafted the rule to be faithful to the constitutional doctrines concerning sealing, for sure. But what the rule does not define, and what I'd actually like to discuss in more detail, is the burden that rests upon one attacking a sealing order under subsection H. What subsection H basically says is if you're going to unseal, look at the same standards as prescribed in subsection C, which is reasonable enough, but it does not define what competing showings might be at issue. It only defines the threshold for sealing. So are you aware of any law that we might need to consider on that other side of the
Whether
balance?
The standard has changed in terms of burden of proof? No, Your Honor, I am not aware of anything in that regard. I can point to the fact that
I just want to make sure I'm understanding. When you say burden of proof, whose burden of proof?
But that, I think, is what you were asking me, as to whether the burden shifts as to the one who is seeking unsealing as opposed to the one who is seeking sealing.
Correct, yes.
And that, Your Honor, I'm not aware of any case law on it. I can say that the cases that are dealing with the sealing issue do make clear that a trade secret in and of itself is enough to be a compelling interest that overrides that public interest in getting access to court filings. That's what we have. And
I understand that, and I'll give you a crack at what I think is one of the more interesting questions left open in the law today. If prior restraints are unconstitutional, how can the little Uniform Trade Secrets Act justify prior restraints every day of the week?
Your Honor, I don't have an answer to that one.
I don't
think that's
expect
really
you to,
issue,
but we come close to reaching that question in this setting, right? I mean, if we're going to use trade secret status as the basis for the compelling interest, and I agree with you that it could very well be, we then have to ask what consequences flow from that, and it would seem that because the Trade Secrets Act contains no exceptions for public interest, that there's an absolute bar on the release of the information, and yet
and that's what I would say.
Restraint.
But that's what I would say, Your Honor, the case law does hold. And I would point the court to Electronic Arts in the Ninth Circuit that said, as a matter of law, under Nixon and Kamakana, the trade secret must remain sealed. DRK cited that, and this court in the Supreme Court, in enacting Rule 5.4, cited DRK as the reasons for this rule, which says that when you have a compelling interest or an overriding interest, that is what supports sealing and doesn't take into account things like a potential risk. Let me note also that one of the factors here that was taken into account by the court in ruling that these documents should be unsealed was the arguable misuse of a protective order. That is effectively a sanction for an arguable misuse with no due process, no proportionality, no findings of fact.
At some point along the road, the misuse has become less than arguable, right? I mean, we have a fair line of cases right here in this case dealing with discovery abuse.
But the discovery abuse that was at issue here was in the Hager 1 case, and it was discovery abuse under the protective order. There was no finding whatsoever of any violation of any protective order. What this court did in Hager 2 was to say there's an arguable misuse because you don't have sharing provisions in your protective orders, which is standard, because you settled your cases, which is standard and encouraged, and because we complained about the already settled plaintiff's counsel spoon-feeding the interveners. That's it. That's the only alleged arguable misuse. And there's no proportionality to say, all right, we're going to take away all of your property rights. We're going to eliminate your trade secrets.
I'm inclined to agree that discovery sanctions and elimination of trade secrets are not really to be spoken of in the same sentence. But let me ask you a very basic question. Is there any material that has been ordered unsealed that is outside the trial court's finding of trade secret status?
Your Honor, we called those documents carefully to try and make sure that the only ones left were the ones that really did meet the trade secret status or the settlement issue.
Well, not your position, though, but the trial court specifically found that,
yes,
that there was trade secret protection to which some of this material is entitled. Would you say that the trial court's finding fairly was intended to apply to every document that it ordered unsealed?
I would, Your Honor, because the court did not call out anything and said these are not trade secrets. The court in conclusion of law 3.4 said Goodyear demonstrated how disclosure of these various kinds of documents can be competitively harmful and which documents contain those kinds of harms. He said that. The only thing he said is the reason why it did not have protected status here was because we did not explain the exact harm from the release of a specific document, giving the example of not having described the specific part of tire testing procedure that's unique to Goodyear. That is asking precisely for the trade secret. You tell me how adding, using X and Y chemical to test against the tire in this stage of its proceedings. That's what he said is missing, and that's just not the right standard. He said that, and that's in the context of 26C4, so going to that. But that is not the right standard as a matter of law. If you look to cases like Beckman and you know, the compelling interest standard, certainly under 5.4, a trade secret can be determined by examples and articulated reasoning. And we had that. And he recognized that in 3.4. He's just saying you have to spell out your precise trade secret in this record that can then be unsealed in order to stop unsealing and to protect the documents that are in the protective order. That's just not right as a matter of law. He looked at these in camera. He determined that they were trade secrets for the reasons that we said, and the only thing he said was we didn't explain more specifically. The court then said that these are not to be protected because of the age of the documents. And, you know, Coca-Cola's trade secrets have existed for over 100 years. Age is not enough. It's not enough under IMCI, the law in Arizona, that trade secrets can continue indefinitely if they have not been disclosed. We also have evidence in this record that tires are iterative, that the specifications and the procedures
I wonder though
were
if you
in fact
even
and
need
are
to make
still
this
used today.
argument. Didn't you already win this argument below? Basically, the trial court already found that these are trade secrets. So
He did find that they are trade secrets, but then he
just
discounted them. He said, yes, they're trade secrets, but they're old, so it doesn't matter if they get produced. And that's simply wrong under EMKI. It's wrong under the evidence that's in this record that these are, in fact, trade secrets, that you need this because our competitors include new entrants into the market that are, in fact, using 20-year-old procedures and 20-year-old specifications, and we are giving them the access to all of that information. We are giving them the specifications. We're giving them the testing. We're giving them the adjustment data to find out how these tires are doing. And then there are changes to the specifications to adjust to those changes that the adjustment results show. And then the tires are improved. And we're giving them all of this. That's what the competitors, the new entrants into the market, get. And then they can also go out and say, oh, you know, Goodyear had these kinds of customer complaints. We don't. Therefore, help even more in competing against Goodyear. The age of the tire is simply not a reason for discounting this. The court then also said there's a presumption of public access. That was also an error as a matter of law. Seattle Times says no. The Supreme Court said no. Bond in the Ninth Circuit said, you look at the old cases like San Jose, those are before changes in the federal rules. And we have Pyle in Arizona that says there is no presumption of public access.
My original question, there is a presumption of public access to judicial records.
Right. That's the ceiling.
And I think your point, if I understand you, is there is not a presumption of public access to discovery materials.
Correct.
Because those types of access presumably would serve two different purposes.
Correct.
Right? One is to monitor the government, one is to monitor a private actor.
Right.
And that gets back to whether there's any sort of sliding scale on the public, on the challenger's side of the ledger, on the burden that the challenger might face to meet the standards articulated in 5.4C.
Right.
And Do you have anything to propose?
I guess I would propose that certainly when the trial court is applying standards that do not meet the law in the state and in the Supreme Court, that in and of itself, this is reversible error. Whether it is the burden of the party that's upholding it to try and persuade the court otherwise, I think that makes sense. I would also say that it is certainly the burden of the party who's upholding it not to come in and make arguments that are contrary to law.
The Fultz case seems to suggest that there's really no burden at all.
But that's a federal case, and we're talking about Arizona, and federal law does not include things like the need, having the plaintiffs come in, the party here, the intervener, coming in and proving their need. That's not in theirs.
But
here, there was no evidence. They presented that they actually need our trade secrets. They have information that there have been a number of accidents and a number of injuries. That's all they need to be able to advocate to the public and to NHTSA to go ahead and do its job. NHTSA is the one who knows how to analyze the specifications and analyze the adjustment data and not draw false conclusions that a member of the public can draw from the fact that there were X number of customer complaints, some of which can be for completely innocuous things, and we don't have that information here. NHTSA is the one to determine this. I would also note that I would urge the court, when evaluating this public risk, this potential public risk, that the potential public risk cannot just outweigh the compelling interest in trade secrets, the lack of need on the part of the parties involved, that effectively what the court would be doing would be to say that whenever you have a products liability case, then an intervener can come in afterwards, the public can come in afterwards and say, oh, we want all of the trade secrets that have been exchanged in this case so that the public can know, because there's a potential risk. These parties got hurt, other parties can be getting hurt. Here, we aren't even talking about a products liability case. This particular case was a settlement fraud case. I mean, you can have a patent case where you have lots of trade secrets, but somebody comes in and says, oh, I think cell phones are going to cause brain injury. There's a potential risk here, and therefore we should weigh that and weigh it so heavily that it's going to outweigh these other factors. It simply is not the correct precedent, I would urge, for this court. It is contrary to Arizona public policy as set forth in the Trade Secrets Act. And let me reserve my last few minutes for rebuttal, if I may.
You may.
Thank you.
May it please the court, my name is Ellen Noble, and I represent the appellee, the Center for Auto Safety. Your Honors, opposing counsel focuses on the fact that the court below called some of the documents at issue trade secrets.
And that they do, and I think that's important, but let me give you the chance to answer the same question. Which documents ordered unsealed did the court not call trade secrets?
Your Honor, the court went through a certain general categories of information. It didn't specify any particular document at issue, so it would be hard to judge exactly what they were calling or not calling trade secrets.
So a fair interpretation of the court's order would leave us uncertain what it found trade secrets and what it did not. Would that be
That's right,
statement?
Your Honor. And we think that actually, if you look at the factual findings of the court below, those could tell you that none of the documents are trade secrets, since they found that there was no specific showing of harm. So that would be
the court specifically said these are clearly trade secrets. It's just unclear what it meant by these.
Correct, Your Honor. Our argument is that you could say that label or use of terms trade secrets was inaccurate given the factual findings made by the court. But you don't have to do that either, because the question on appeal is not whether or not these documents are trade secrets. The question is whether or not Goodyear showed significant identifiable harm from disclosure of the information that outweighs competing interests, or for court records, a substantial probability of a clearly defined and serious injury.
Where do you get that? Where do you get that standard?
Which standard, Your Honor? Both standards are from various appellate court decisions interpreting Rule 26, which the Arizona court has said in its comment to Rule 26 we should look to when determining what constitutes good cause.
Right, but we have a rule that was promulgated before the trial court ruled here that's nowhere discussed in the briefing, and I have to admit that caused me some frustration getting ready for this case, and that articulates a standard that doesn't look like Foltz, doesn't look like these other cases you've cited. Why shouldn't this case be analyzed under the governing Arizona rule?
So Rule 5.4 with respect to sealing court records does look a lot like Maricopa Local Rule 2.19. In fact, it has almost all of the same factors except for one, which seems quite redundant, number
It's
2.
not entirely coincidental, yes.
And the court below applied that local rule, which is not inconsistent with the new 5.4 rule. So we think there's no reversible error or anything of the sort with respect to its application of the Rule 5.4. Additionally, with respect to whether or not the documents being trade secrets matter, whether or not the documents are trade secrets don't satisfy is not part of the analysis for either of the standards, whether we're looking at Rule 5.4 or Arizona Rule 26. For example, just last month, a Western District of Pennsylvania court looked at a case and said, the information at issue here is confidential business information. But because the party never showed how it would suffer a clearly defined or serious injury, that these documents need to be unsealed.
Okay, but let me get then to my interesting constitutional question. Would you claim that the Uniform Trade Secrets Act is unconstitutional because it effectively mandates the prohibition of publication of these documents in the face of New York Times against the United States?
Your Honor, I think that would depend on how courts apply the definition of trade secrets under the Arizona law. If it's a potential economic harm from disclosure, so for example, some courts have said it's a very broad definition, then potentially there could be issues. But here, that's not the question.
Well, there's a clear statutory definition that talks about value being derived from secrecy. That is economic by its nature. I don't think it's a very flexible standard. It's what the legislature wrote.
The problem here is that the court below said that there was no showing of any harms with respect to any specific document or piece of information. And that certainly would not satisfy, we think, doesn't even satisfy the definition of trade secrets under Arizona law.
So you agree that the trial court erred then? You just think it erred in a different way? Because the trial court clearly, as clearly as it could have, said this is trade secret information. And so you would say that that conclusion was error because it found no harm and therefore, by virtue of the statutory definition, couldn't have been a trade secret. None of this stuff is trade secret.
That's one option. But the other option is that you don't need to determine whether or not the documents at issue are or are not trade secrets at all. And the final option is, even if they are trade secrets, that would still be entirely consistent with what other courts have held. For example, in Procter v. Gamble, the court held as an alternative holding, even if these documents are trade secrets, there's no showing of good cause because the party failed to articulate how it would suffer a significant harm from disclosure. Likewise, in Contratto, the Northern District of California said in footnote 9 that the documents at issue may very well contain trade secrets, but because the party only made generalized allegations of confidentiality without pointing to any specific information at issue, there was no showing of good cause, and therefore the documents were released.
I'm trying to figure out how to use our time wisely. I could ask you further about that, but I want to shift for a moment to what burden, if any, you think your client should have when it comes into somebody else's litigation, tries to open their protective order, and then broadcast confidential information to the public. Is there any burden at all, apart from saying we represent the public?
Your Honor, the burden is entirely on the party seeking secrecy. Courts have been very clear about this, both with respect to discovery documents and court records, that the burden is on Goodyear to establish a particularized showing of good cause. That's even in a Supreme Court decision in footnote 9 or 16 in Gulf Oil. And with respect to court records, again, a specific showing of compelling reasons.
So a person waiting in front of the courthouse for their traffic court hearing could amble into the clerk's office and say, I'm interested in what's going on in that protective order, and put the parties to a tremendous burden of justifying their stipulated protective order and again, with regard to discovery materials only, not the workings of the court, with no burden. And any requester.
Yes, Your Honor, but 2 points. First, in those circumstances, the burden shouldn't be that difficult if the information is truly going to cause significant confidential harm. They can point to, explain, provide that specific demonstration of fact that the rule calls for and say that that's what those documents are talking about. Second, in this case, the question is much easier because we don't have a random person coming in, and there's a heightened interest on the second step of the test when we're doing a weighing of competing interests, because instead we're looking at the public's interest in access in a tire that not only is 20 years old and was discontinued 15 years ago and is subject to litigation across the country, but is also still on the roads posing a threat to individuals.
How much more does the public need to know than has already managed to leak out before it decides that it might want to consider a different tire? I mean, are you concerned that some member of the public is going to be aware of the NHTSA document and all of the concerns about the lawsuits over this tire, but say, until I know what surfactant they used in the second baking stage, I might still consider that tire?
That's an important point. But that's a reason why these documents need to be released. So almost all of the documents, all the types of information that leg declaration talks about are already public information, including many of the documents that they're continuing to claim are confidential are now public. Thousands and thousands of pages from the submission that went to NHTSA is being declared, is no longer they're claiming confidentiality to with respect to NHTSA.
But what is the public hungering for?
So then the question is, what's the public interest if all these documents are out? There's 2 options. One option is all the remaining documents that aren't already public say basically the same thing of the information that's out there, and it's just a few additional details like you said. If that's the case, then the documents have to be released because it's the burden of Goodyear to show good cause. And if the other option is true, if some of the options that aren't already public information but are still confidential or sealed say something different, if they say something new and are some other type of information, then there's a public interest in access to that information.
Here's the problem, though. The discovery process is not, it doesn't exist for the benefit of the public. It exists for the benefit of ensuring that disputes are litigated fairly. Public access, the right of public access, exists for the purpose of allowing the public to scrutinize the actions of its government. That interest doesn't seem to be implicated in any way in this case. This isn't even a personal injury case. It's one of many cases involving collateral litigation over discovery, about discovery, and I'm not seeing where the public interest lies in accessing that information through court processes. If there was some concern, for example, that the court had mishandled a case, I would be highly sensitive to the public's need to be able to monitor what the court did. But that's not at issue here.
Your Honor, 3 points. First, with respect to whether or not there's a public interest beyond the G159 tire, which NHTSA is investigating, in which those documents are going to be public, the public also has an interest in understanding how Goodyear responded to allegations of a defect, and with your point to the end of how court processes work. They have an interest in understanding how Goodyear used protective orders and settlements to potentially conceal a defect or potential alleged defect for over 20 years. So there's a strong interest in understanding how the court processes work when it comes to cases like this and what they allow parties to get away with the use of protective orders. But then there's also an interest in just understanding how Goodyear, as a large manufacturing company, is going to respond to early warning data of a potential safety risk beyond the G159 tire. And then finally, the public has an interest in understanding how government agencies, not just the court, so including government agencies like NHTSA, are responding to potential threats to public safety. And that's...
Well, I might agree with you, especially on the last point, but this proceeding seems completely unrelated to that concern. There's nothing we can do to assist in evaluating NHTSA's performance?
Your Honor, the documents at issue are the same documents that are about the G159 tire and Goodyear's responses and decisions to recall products, which is overlapping with what NHTSA is investigating. So there's an ongoing public access interest. None of the case law requires that public interest and access to information have to be completely tailored to court processes. But even if that was the standard, there's still a strong interest in understanding court processes because it's important to understand how Goodyear uses settlements and protective orders and other forms of court secrecy to hide potential defects that the public has a right to know about. Finally, not only is Goodyear argues that there was an error in law for failing to show, requiring the party to make a specific demonstration of harm. But every case has said you do need that specific demonstration of harm. What Goodyear did in terms of creating a spreadsheet and then talking about the general categories of information and how they could be used by competitors is exactly what the defendants did in Kamakana, in Parmalat, and in Inri-Bard. And in all of those cases, the court said that's not enough. You can't just tell us why this general information could be used by competitors or this general type of information. You have to talk to us about the specific information at issue with respect to each particular document.
What does that mean, each particular document? A lot of these documents consist of very, very repetitive-looking pages of tables of data. Are you saying that we need a declaration for each one of those pages, and so our 10,000 pages in dispute become 100,000 pages of declarations, and we could write a 500,000-page appellate decision? And at what point are we able to address categories?
Your Honor, that's absolutely not required. You can certainly have an argument that justifies why a category of documents may be confidential. But that argument as to confidentiality needs to be about the specific information at issue and not a general type of information. So, for example, if a party came and said, we've got this proprietary chemical formula, and it's really what gives us a leg up in the industry. It's novel, other people don't have it, and if we lost it, we would suffer significant economic harm. And then they said, these 50 documents are all talking in detail about that formula. Then that would be sufficient. But that's not what happened here.
Why would it need to be that specific? Why couldn't then you also include the testing data afterwards that shows that our formula is actually better than the other ones?
I'm sorry, so if talking...
But in other words,
yeah.
You said it would be limited to the formula and documents that describe or provide for the formula. But why wouldn't the testing data showing how their formula does better be also included in that list of categories of documents that would be protected?
They would have to show that testing data would also cause it a significant harm if released. If it did that, that would be sufficient. But the reason why those general types, talking about the type of information, is not enough, which is what happened here, is because it's very possible, as is likely the case here, that the specific information at issue might not match that general justification. For example, maybe tire designs are sometimes used by competitors, but not in the case in which it's tire designs about a 20-year-old tire discontinued 15 years ago.
Well, but that ground has been plowed pretty well. Designs can be iterative. I mean, there might have been a time after New Coke came out that people said, well, who cares about old Coke? And it turns out that some of that information turned out to be commercially valuable, right? We might say, and so the idea that the tire is 20 years old is marginally persuasive on the one hand, but it also tends to diminish your argument that the public continues to face risk from this 20-year-old tire, right? Nobody's buying it anymore. It last was sold in 2006. So what members of the public riding around on motorhomes on 13-year-old tires are really looking for test data to make sure that they shouldn't change their tires at this point?
Well, we know 40,000 tires were sold and that there are tires that remain on the road. But with respect to the question of old information, whether or not...
I mean, it cuts both ways,
Yes.
is my point.
Exactly. And there's 2 points there. First, we're not saying old information could never have to be confidential or valuable. The point is that it's their burden to demonstrate why it still is. Why are these design information still being used by Goodyear today? And not only why are they being used, but are they something novel in the industry that's not common across the board? That showing of fact was never done here. And second, even if in this case, that kind of information is already public. All of these things that we're talking about as trade secrets are in the NHTSA submission. That information no longer can be confidential business information if it is not in fact confidential.
Because it was already misappropriated. I mean, the leak to NHTSA was not entirely sanctioned, right?
The submission to NHTSA there was a different issue with the journalist getting access to the submission to NHTSA, but NHTSA has now said...
Wasn't there an issue with a clerk mistakenly releasing
Yes,
documents?
and that's how information got to a journalist. But NHTSA has now said, we are not recognizing the confidentiality of these documents, and Goodyear is not appealing that decision. So those documents, under NHTSA's own determination as to whether or not those contain trade secrets, was that they're not, and we're not recognizing confidentiality with respect to thousands of pages of documents that are the same documents at issue still in this case, and that we still have an ongoing claim of confidentiality to. Finally, even if the court went on and said, even if you think some potential harm could come from disclosure of this information, that harm does not outweigh the public's interest in access. Goodyear admits on page 7 of their reply brief that the same legal standard applies and that there's a weighing analysis to be done. They just take issue with how the court weighed those competing factors. We're not saying that all of a sudden everyone can go release trade secrets. We're talking about in this case in which there was a specific finding that there would be no harm, or if any harm, very minuscule, from disclosure of the information at issue. And we have a history or track record of the use of protective orders in ways that enabled discovery fraud or allowed for gamesmanship, as would happen in this very own proceeding below. And then finally, we have a situation in which the information under the standard required by Rule 26 relates to or reveals a threat to public safety. So looking at all three of those factors, the court made the context-specific decision. And the Supreme Court in Arizona had said in Lewis that it's really important to give full discretion when they're looking at that balancing test, because the trial court is the court that best understands the complexities at play and those factual determinations. All of the arguments being made are arguments that we're reviewing, are factual findings being reviewed for abuse of discretion. They're not legal, they're not contesting that the court applied the proper good cause or compelling reason standard in itself. Finally, very briefly, they talk about a false presumption in favor of discovery documents, but that's not what the court did. The court set a sentence, and it's a sentence you've seen in a lot of opinions, that pretrial discovery is, absent a protective order, presumptively public in the sense that parties can share that information with the public. And that's all we're asking for here.
Well, absent a protective order, yes. But the idea of the public coming into litigation and demanding access that the parties decline to share has always been a more difficult concept, yes? Even absent a protective order, if you have plaintiff and defendant in a garden variety case and let's say the press wants to come in and see the discovery materials, both parties say respectfully no. There's no protective order, but no. What is the best case that says the court can order them to share discovery materials that have not been actually filed with and used by the court?
That's simply not the relief we're requesting in this case.
I understand. Yeah. But you drew an analogy, and I'm trying to put it in context.
So I imagine that there are different standards at play when someone is trying to get direct access to discovery materials. That would be a higher burden. But we're not trying to get direct access to discovery materials, and the law recognizes that absent a protective order, there's a free right to disseminate that information that was received during discovery. Finally, thank you for your time.
You're out of time. Thank you.
Let me address first, Your Honor, Susan Freeman for the Goodyear Tire and Rubber Company. Let me address first the notion that these documents are all out there anyway. There are over 30,000 documents in all. There were 27,431 in Category A, 7,207 Category B, 1,243 in Category C, and substantially fewer than those that were leaked to the press and are now public. There are a lot of documents that are not the same. The ones that plaintiff's counsel thought were the best to persuade NHTSA were the ones that he put in there. But there are a lot of specifications and drawings and adjustment data and so forth that are still sealed, and appropriately so. With respect to the court not, or with respect to our filings, our evidence being general and not categorical, I would ask the court to look at the example in DRK where the court laid out what additional evidence was included with respect to trade secrets. Ours is far more specific than that one, and that's what this court, or that's what the Supreme Court used as its standard for saying what needed to be evidence by way of sealing. Apple Samsung is similar in terms of you have a competitive need for it.
Do you disagree with your opposing counsel's argument that the local rule in Maricopa County Superior Court is essentially the same as the new Rule 5.4?
It is substantially the same, Your Honor, and I would note that it does not include a potential risk or plaintiffs saying that they need these documents. Those are not included in the local rule, so even if the court was applying that local rule, it erred as a matter of law by taking those into account in determining that documents should be unsealed.
So your argument remains, even though you didn't cite it to the court below, that the court erred below by not applying the balancing test required, or the
or
factors
by
required.
Applying a balancing test and including these
Right.
other factors
Sorry.
that it should not have, including like age of the tire and so forth.
Should have been limited to the rules under 5.4.
Yes, 5.4 was incorporating that law of Kamakana and Nixon. And
Then what is the remedy you're asking of us?
the remedy, Your Honor, would be to I'd be happy with your saying that trade secrets as a matter of law should not be unsealed, because that's what Rule 5.4 says, but send this back to the trial court to apply the right standards, remand to the trial court to do that. I mean, in terms of the standard, the burden of proof, I would note in response to Your Honor's question that Rule 26 has language that the burden of good cause for an order remains with the party seeking confidentiality. Rule 5.4 does not, and the normal rule with respect to a movement is that the movement has the burden of proof to come in. So the court can take that into consideration. I would also note that in terms of the specific examples and articulated reasoning, that we did show the harm that was needed. I'm sorry, I do see that I'm out of time.
You finish your sentence.
That if the court goes back to look at our affidavit, the Legge affidavit, it does meet all of those standards and certainly within the tests of like the DRK case. Thank you, Your Honor.
Thank you very much to both parties for your briefs and arguments here today. We will take this matter under advisement and will issue a written ruling in due course. We will now be at recess to allow the next case to be set up for their oral argument.